We had a case involving LaborReady, which supplied workers to Walmart. The workers were employed by LaborReady, received their check from LaborReady, and in the application, they had buried in there a forced arbitration class action waiver agreement. They were being paid by LaborReady for 8 hours a day, every day, same amount of time exactly. But when they actually went to Walmart, they were required to stock shelves and they weren't allowed to leave until the job was done. So on many days, they were there for 8 hours and 45 minutes, 8 hours and 30 minutes, so forth. A straightforward wage theft operation. When we filed the case, LaborReady sought to force us into arbitration. We decided, because Walmart was also the end user of the workers and they had liability under Illinois and federal law, we would drop LaborReady and just proceed with a class action against Walmart because there was no arbitration agreement between Walmart and the workers. However, Walmart went into court and argued that they were an intended third-party beneficiary of the agreement between the employees and LaborReady. In other words, even though they were not a party to the agreement, they were intended to be covered by the arbitration agreement. The court agreed. We were forced into arbitration. Thousands of dollars stolen from thousands of workers was not able to be prosecuted as a class action, a single class action for all these workers. But instead, each was forced individually into arbitration to try and bear the cost and recover the amount of money that they were owed. And keep in mind, these are minimum wage workers. The amount that they were owed was relatively small, but large to them. And the cost for them to try and pursue those claims individually was almost prohibitive. The companies that use staffing agencies don't want to acknowledge that they are employers of those individuals. And so they're careful not to have any kind of agreement with the employees, including an arbitration agreement. But then at the end of the day, they want to have it both ways. They want to deny that they are an employer of record and yet turn around and benefit from an agreement with an employer of record. And so the court agreed with Walmart in our case, and we were forced to arbitration. We were able to recover pay for some people, but there are a whole lot of people who never recovered their pay.